Michigan Constitution of 1963. Article 5, Section 1. Except to the extent limited or obligated by Article 5, Section 2, or Article 4, Section 6, the executive power is vested in the governor. Section 2. All executive and administrative offices, agencies, and instrumentalities of the executive branch of state government and their respective functions, powers, and duties, except for the office of governor and lieutenant governor, and the governing bodies of institutions of higher education, provided for in this Constitution, shall be allocated by law among and within not more than 20 principal departments. They shall be grouped as far as practicable according to major purposes. Subsequent to the initial allocation, the governor may make changes in the organization of the executive branch or in the assignment of functions among its units, which he considers necessary for efficient administration. Where these changes require the force of law, they shall be set forth in executive orders and submitted to the legislature. Thereafter, the legislature shall have 60 calendar days of a regular session, or a full regular session if of shorter duration, to disapprove each executive order. Unless disapproved in both houses by a resolution concurred in by a majority of the members elected to and serving in each house, each order shall become effective at a date thereafter to be designated by the governor. Notwithstanding any other provision of this Constitution, or any prior judicial decision as of the effective date of this constitutional amendment, adding this provision, which amends Article 4, Sections 1 through 6, Article 5, Sections 1, 2, and 4, and Article 6, Sections 1 and 4, including this provision, for purposes of interpreting this constitutional amendment, the people declare that the powers granted to Independent Citizens Redistricting Commission for state and congressional districts, hereinafter commission, are legislative functions, not subject to control or approval of the governor, and are exclusively reserved to the commission. The commission and all of its responsibilities, operations, functions, contractors, consultants, and employees are not subject to change, transfer, reorganization, or reassignment, and shall not be altered or abrogated in any manner whatsoever by the governor. No other body shall be established by law to perform functions that are the same or similar to those granted to the Commission in Article 4, Section 6. Section 3. The head of each principal department shall be a single executive, unless otherwise provided in this Constitution or by law. The single executives heading principal departments shall include a Secretary of State, a State Treasurer, and an Attorney General. When a single executive is the head of a principal department, unless elected or appointed as otherwise provided in this Constitution, he shall be appointed by the governor, by and with the advice and consent of the Senate, and he shall serve at the pleasure of the governor. When a board or commission is at the head of a principal department, unless elected or appointed as otherwise provided in this Constitution, the members thereof shall be appointed by the governor, by and with the advice and consent of the Senate. The term of office and procedure for removal of such members shall be as prescribed in this Constitution or by law. Terms of office of any board or commission created or enlarged after the effective date of this Constitution shall not exceed 4 years, except as otherwise authorized in this Constitution. The terms of office of existing boards and commissions, which are longer than 4 years, shall not be further extended except as provided in this Constitution. Section 4. Except to the extent limited or abrogated by Article 5, Section 2, or Article 4, Section 6, temporary commissions or agencies for special purposes with a life of no more than 2 years may be established by law and need not be allocated within a principal department. Section 5. A majority of the members of an appointed examining or licensing board of a profession shall be members of that profession. Section 6. Appointment by and with the advice and consent of the Senate, when used in this Constitution, or laws in effect or hereafter enacted, means appointment subject to disapproval by a majority vote of the members elected to and serving in the Senate, if such action is taken within 60 session days after the date of such appointment. Any appointment not disapproved within such period shall stand confirmed. Section 7. Vacancies in any office, appointment to which requires advice and consent of the Senate, shall be filled by the governor, by and with the advice and consent of the Senate. A person whose appointment has been disapproved by the Senate shall not be eligible for an interim appointment to the same office. Section 8. Each principal department shall be under the supervision of the governor unless otherwise provided by this Constitution. The governor shall take care that the laws are faithfully executed. He shall transact all necessary business with the officers of government and may require information in writing from all executive and administrative state officers, elective and appointive, upon any subject relating to the duties of their respective offices. The governor may initiate court proceedings in the name of the state to enforce compliance with any constitutional or legislative mandate, or to restrain violations of any constitutional or legislative power, duty, or right by any officer, department, or agency of the state, or any of its political subdivisions. This authority shall not be construed to authorize court proceedings against the legislature. Section 9. Single executives heading principal departments and the chief executive officers of principal departments headed by boards or commissions shall keep their offices at the seat of government, except as otherwise provided by law, superintend them in person, and perform duties prescribed by law. Section 10. The governor shall have power, and it shall be his duty to inquire into the condition and administration of any public office, and the acts of any public officer, elective or appointive. He may remove or suspend from office for gross neglect of duty, or for corrupt conduct in office, or for any other misfeasance or malfeasance therein, any elective or appointed state officer, except legislative or judicial, and shall report the reasons for such removal or suspension to the legislature. Section 11. The governor may make a provisional appointment to fill a vacancy occasioned by the suspension of an appointed or elected officer, other than a legislative or judicial officer, until he is reinstated or until the vacancy is filled in the manner prescribed by law or this Constitution. Section 12. The governor shall be commander-in-chief of the armed forces and may call them out to execute the laws, suppress insurrection, and repel invasion. Section 13. The governor shall issue writs of election to fill vacancies in the Senate or House of Representatives. Any such election shall be held in a manner prescribed by law. Section 14. The governor shall have power to grant reprieves, commutations, and pardons after convictions for all offenses, except cases of impeachment, upon such conditions and limitations as he may direct, subject to procedures and regulations prescribed by law. He shall inform the legislature annually of each reprieve, commutation, and pardon granted, stating reasons therefor. Section 15. The governor may convene the legislature on extraordinary occasions.